Hey guys, welcome back to the channel. This is the House of Law and I am Attorney Al Jumrani. This is episode 4 of Civil Law Jurisprudence by Justice Marvic Leonen. If you missed the third episode, you can watch it through the link above or the link in the description box below. In this episode, I will talk about 3 more Supreme Court decisions penned by Justice Marvic Leonen. The first case is about easement of right-of-way. The second case has 2 issues: the right of a lessee to suspend payment of the rent in a lease contract and the right of the seller to forfeit the earnest money in a contract to sell. The third case is about an action to recover real property filed by a non-Muslim before the Shari'a court. Let's begin. Our first case is Alicia B. Reyes versus spouses Francisco S. Valentin, GR number 194488, February 11, 2015. In this case, the property of the spouses Valentin was standing between the property of Alicia Reyes and the barangay road. Both properties were earlier owned by the same person, but when the property was subdivided, there was no provision for a right-of-way. There is a public road near the other side of the property of Alicia Reyes, but it was separated by an irrigation canal of the National Irrigation Administration. So, Alicia Reyes filed a complaint for easement of right-of-way against the spouses Valentin, demanding around 100 square meters along the boundary line of the property of the spouses Valentin. Both the Regional Trial Court and the Court of Appeals denied the prayer for an easement of right-of-way on the ground that the requisites of an easement of right-of-way were not met. So, what are these requisites and what specific requisite or requisites were not met? Applying Article 649 and 650 of the Civil Code, the Supreme Court ruled that the requisites of a compulsory easement of right-of-way are: first, an immovable is surrounded by other immovables belonging to other persons and is without adequate outlet to a public highway. Second, payment of proper indemnity by the owner of the surrounded immovable. Third, the isolation of the immovable is not due to its owner's acts. And fourth, the proposed easement of right-of-way is established at the point least prejudicial to the servient estate and insofar as consistent with this rule, where the distance of the dominant estate to a public highway may be the shortest. So in this case, it was found that Alicia Reyes has access to a different public road, although it was separated by an irrigation canal. Alicia Reyes only had to construct a bridge over the irrigation canal. Definitely, this was a longer distance and maybe more costly because Alicia Reyes had to construct a bridge. However, when there is a conflict between convenience to the requesting property, also called the dominant estate, and the prejudice caused to the requested property, also called the servient estate, the criterion of least prejudice prevails over the criterion of convenience. The portion of the property being requested for an easement of right-of-way had been constructed with a garage, a garden, and a grotto. All these would be destroyed just so Alicia Reyes can have a shorter right-of-way to the public road. Contrast this with the other access, which only requires a permit from the National Irrigation Administration to construct a bridge over the irrigation canal. So the moral of the story is that when requesting for an easement of right-of-way, ang dapat isipin ay hindi lang kung ano ang madali para sa'yo. Dapat isaalang-alang din yung perwisyo o abala sa may-ari ng lupang madadaanan ng right-of-way. The second case is Victoria N. Racelis versus spouses Germil Javier, GR number 189609, January 29, 2018. In this case, Victoria Racelis was the administrator of her father's property in Marikina City. Sometime in August 2001, the spouses Javier offered to buy the property, but that they needed more time to raise the purchase price of around 3.5 million pesos. In the meantime, they would like to lease the property for 10,000 pesos monthly. Racelis agreed. She asked the spouses Javier for a down payment of 100,000 pesos and allowed them to lease the property. Out of the 100,000 pesos, the spouses Javier were only able to pay 78,000 pesos in irregular installments. Realizing that the spouses Javier could not raise the down payment, more so the purchase price, Racelis notified the spouses Javier that the lease contract will be terminated and that they should pay their back rentals and that the 78,000 pesos would be forfeited. The spouses Javier, however, claimed that they stopped payment of the rent after Racelis cut the electrical service, a disruption of their peaceful possession of the leased premises. Also, they claimed that the 78,000 pesos should either be returned or be set off with the unpaid rents. So the two issues in this case are, first, whether the spouses Javier as lessees had the right to suspend the payment of the rent, and second, whether the 78,000 pesos can be returned or set off with the unpaid rents. On the first issue, the Supreme Court held that the unpaid rents were pertaining to the months prior to the cutting of the electrical service. The electrical service was cut only after the lease was terminated. Besides, assuming that respondents were entitled to invoke their right under Article 1658 of the Civil Code, this does not exonerate them from their obligation under Article 1657 of the Civil Code to pay the price of the lease according to the terms stipulated. Lessees who exercise their right under Article 1658 of the Civil Code are not freed from the obligations imposed by law or contract. Clearly, when so warranted, the lessee can only suspend the payment of the rentals, but when the cause or ground ceases, the lessee should resume payment of the rent, both present and overdue. On the second issue, the Supreme Court held that aside from a contract of lease, the parties also entered into a contract to sell. In a contract to sell, the payment of the purchase price is a positive suspensive condition that gives rise to the prospective seller's obligation to convey title. However, non-payment is not a breach of contract, but an event that prevents the obligation of the vendor to convey title from becoming effective. The contract would be deemed terminated or cancelled, and the parties stand as if the conditional obligation had never existed. In a contract to sell, earnest money is generally intended to compensate the seller for the opportunity cost of not looking for any other buyers. It is a show of commitment on the part of the party who intimates his or her willingness to go through with the sale after a specified period or upon compliance with the conditions stated in the contract to sell. In this context, this earnest money can be considered as an option money. So in this case, since the spouses Javier failed to deliver or pay the purchase price at the end of 2003 as agreed, the contract to sell was deemed cancelled. The contract's cancellation entitled Racelis to retain the earnest money or to forfeit this earnest money which was given by the respondents. Our third and last case for this episode is Vivencio B. Villagracia versus 5th Shari'a District Court, GR number 188832, April 23, 2014. In this case, a certain parcel of land in Parang, Maguindanao was the center of controversy. Roldan Mala, a Muslim, purchased the property from one Ceres Cañete. The property, however, was then occupied by Vivencio Villagracia, a non-Muslim. At first, Roldan initiated barangay conciliation proceedings but failed. Roldan then filed an action to recover the possession of the land against Vivencio before the 5th Shari'a District Court in Cotabato City. Despite receipt of summons, Vivencio failed to file an answer. Thus, the plaintiff Roldan was allowed to present evidence ex parte. Consequently, the Shari'a court rendered a decision declaring Roldan as the rightful owner and ordering Vivencio to vacate the property. Vivencio appealed to the Supreme Court, arguing that the Shari'a court had no jurisdiction over him because he was a non-Muslim, that the Shari'a court can only hear and try real actions or those involving ownership and possession of real property if both parties to the case are Muslims. Remember, Roldan was Muslim, but Vivencio was not. But the Shari'a court ruled that it had jurisdiction and properly decided the case because it applied the civil code and not the Muslim personal laws of the Philippines. So the issue in this case is whether the Shari'a court can try a case for recovery of possession of property involving non-Muslim parties by applying the civil code. To this, the Supreme Court ruled that the Shari'a court does not have jurisdiction. Sharia courts, after all, are courts whose jurisdiction is primarily over matters governed by the Code of Muslim Personal Laws. On the other hand, regular courts have jurisdiction over matters governed by general laws of the Philippines. Here, the application of the provisions of the Civil Code of the Philippines by the 5th Sharia District Court did not validate the proceedings before the said court. The concurrent jurisdiction of Sharia courts over real actions arise only if the parties involved are Muslims. Considering that Vivencio is not a Muslim, respondent 5th Sharia District Court had no jurisdiction over Roldan's action for recovery of possession of real property. The proceedings before it are void regardless of the fact that it applied the provisions of the Civil Code of the Philippines in resolving the action. So there, just one of the very rare cases where the Supreme Court explained the unique system of Sharia courts vis-a-vis our regular courts. So thank you, Justice Leonen. Alright guys, that's it for episode 4 of the Civil Law Jurisprudence by Justice Leonen. I hope may natutunan kayo today. For the bar reviewees, take note of these cases baka lumabas sa bar exams this November. Please drop a like if you like this video. Please subscribe to support me and click that notification bell to be alerted when I upload a new video. So till next video ha, laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!